Welcome to this free immigration help channel. Today is June 12, 2023, and we are getting into the volume 115 of me answering your immigration related questions. As you can see, I have all your comments pulled up in front of me. Before we begin, I'm gonna mention I am not an immigration attorney. This is not a legal advice. All the information provided in these videos on this channel are directly from the official government sources like USCIS and of course the Department of State with their visa bulletin. So without further ado, let's start with the very first. Well, looks like the first comment from Sajjad Mahdi says, thanks for responding. Sajjad, you're very welcome. I hope my response was helpful to you. Moving further to Rihanna Singh, sorry if I'm mispronouncing the name. Hi sir, I'm from South America. F3 with priority date December 12, 2012. I received I-797 3 years ago. I recently came to the US with B1, B2 visa. Great. Will everything be canceled if I overstay? Rihanna, great question. So absolutely, I do not recommend overstaying. Please don't overstay. You definitely don't want to do that because 100% if you do overstay, whether you are going through the interview here in the United States of America in one of the USCIS field offices or in the US embassy in the country, in South America, in one of the US embassies, and I'm talking about the very last interview for the immigrant visa, you will have that question why you overstayed, and you don't want problems like this. So I definitely don't recommend that. What you can do, and if you really want to stay here while waiting for the immigrant visa to become available for the interview, so far so forth, what you can do is you can file for an extension of your B1, B2 non-immigrant visa and remain in the country while that application is pending. As of right now, these applications, they take very, very long time to process, like over a year, I think, currently for the extension for B1, B2. So while it is pending, you can remain legally in the country. The only concern with that, if you're remaining in the country, is obviously it will have to be switched because currently I'm sure NVC they think that you will be going through the interview in the US embassy in your home country, so they will have to give you an option to go through that interview here in one of the field offices, one of the immigration field offices. But let's take a look at the visa bulletin and see what it looks like for F3 as of right now. So it's December 12th, 2012. F3, let's take a look. We're gonna look at the graph A, and F3 right now is showing, looks like for all chargeability area is December 2008. Okay, so you still have a little bit of time. You still have roughly 4 years before the availability of the immigrant visa. And let's take a look. And looks like you have about 1.5, maybe 2 years before the NVC portal is fully open so that you can become documentarily qualified. So honestly, if you need to remain in the country, in the US longer, I don't see a problem at all filing for a B1, B2 extension and then staying here for longer. You won't be able to stay here as long as 4 years to wait for that interview, because 4 years is a little bit of a long time, and definitely do not overstay. 100%, that is definitely a big no. But one thing that I would recommend you do is because you have about 1.5 to 2 years closer to the NVC portal fully opening up, I would recommend doing your research on becoming documentarily qualified, what that entails, what kind of documents are required. I have a video on this channel. In fact, here it is right underneath. It's called Documentarily Qualified. What does it mean? Real NVC case. And in that video, I show an actual NVC portal where a beneficiary was already documentarily qualified. In fact, they already got their permanent residence. But you can see it, and you can kind of get an idea of exactly what is required to become documentarily qualified. The application, all the fees, what documents, so that you can prepare all of it. When the NVC portal opens up, you can be ready and just submit everything and become documentarily qualified pretty quickly, and that's it. Then just it's a matter of waiting for the immigrant visa to become available. Alrighty, well, let me put this, and we're gonna move on to the next question. Looks like multiple questions, actually 4 comments from Stefan Gannon. Hopefully I'm pronouncing the name correctly. My priority date is March 14, 2017. Until now, no more email the NVC to me, sir. Why it's too long, sir? It's long here to wait, sir, my interview. My priority date is March 14, 17. Until now, sir, I cannot wait my interview, sir. Okay, Stefan. I can't answer anything from what you posted four times. If you want me to estimate, rough estimates for you, I'm gonna need, I already know your priority date, but put it again, please, in a separate comment. Put the preference category, because obviously you are in one of the preference categories that's dealing with the visa backlog because you've been waiting since 2017. So it means that you are waiting. You're waiting for the availability of the immigrant visa, and also the chargeability area. It will be helpful because some of the chargeability areas, they take much longer. Just make sure, please, don't respond to my comment within your comment because I'm not going to get notification for it. Submit it as a separate comment. Again, priority date, and that goes for everyone. If you are asking me for estimates on the visa bulletin, I'm going to need your priority date, the preference category, and the chargeability area. This three things. Obviously, it will help if you say whether or not you're documentarily qualified or not. That would be helpful. But the three things minimum is what I need to establish that kind of rough estimate. Okay, let's move on to the next question from Peterson. Peterson says, what answer correct when they ask my immigration status, please? If I enter to the border, I have my I-94. I don't really know what status can I choose. Please help me. Okay, Peterson. So I'm going to need a little bit more information. If you can, I'm going to request you submit a separate comment as well with some additional information. So when you say you enter the border, are you referring, because you can enter the border at one of the ports of entries, and you with a certain status that you came into the country. It can be a non-immigrant visa, it can be an immigrant visa, it can be refugee, it can be a whole bunch of different things. Or you're referring to illegally crossing the border, because if you illegally cross the border, I don't think that's the situation in your case, because when you illegally cross the border, you don't have the I-94. You do have the I-94, so that tells me that you definitely came into the country legally and you got the I-94. So please let me know a little bit more details, and I'll see if I can provide a better answer for you with a little bit more information. But you're asking the question on I-821 application for temporary protected status, and you're asking about one of the what status you currently have. And again, if you do have the valid I-94, which is a valid duration of stay, the duration of stay was given to you based on a certain entry, however you entered the country, based on, but again, it was a legal entry. It was either through visa or refugee status or something along those lines. So let me know a little bit more information, and I'll try to do a better job answering your question, Peterson. Okay, let's move on to the next one. Looks like there's two comments from Rihanna Singh. Oh, Rihanna Singh. I think I already answered Rihanna Singh. Yep, I already answered Rihanna Singh. Let's see if it's the same thing. Hi, sir, my priority F3. Then can you give me an estimate? Already done, Rihanna. So already taking care of this. And then, hi, sir, I received my I-797. Okay, so already answered this. Okay, let's move on to Cindy Vasquez now. Cindy says, what happens if you filed only I-912 and send the fee for the biometrics, but the fee was returned by USCIS because it was not required? This person is looking to replace its permanent resident card, but the Form I-90 was not filed along with I-912. Thus, the process starts all over again. Cindy, yes, so that's why they returned the biometrics fee, because they didn't even know what the biometrics fee is for. Because for I-912, you don't need the biometrics fee. I-912 is just a waiver. And yes, and that goes for everyone. If you are filing the I-912, which is the fee waiver that USCIS, it's their request for a fee waiver. It's a request for a fee waiver on a certain application. And obviously, you have to file that application in order to request a fee waiver on it. So, yes, that was really the only kind of problem with filing the I-912, is that it didn't have the actual application with it. So what it's supposed to look like is you're gonna have your filled out I-90 for the replacement or renewal of the permanent residence card, and then on top of it you're gonna have the I-912, and then you can attach your fees for the biometrics and stuff like this, because biometrics fee is not included in the fee waiver, so you still have to pay for it. But on the plus side, you're saving quite a lot of money if they do approve the I-912, because the application fee for I-90 is, I think it's pretty expensive, like $400. Let me double check that. Let's take a look. Might as well use this as an opportunity to demonstrate some navigation on USCIS, which is the official government website for U.S. Citizenship and Immigration Services, uscis.gov. So we're gonna go to Forms, and then All Forms, and then I'll just type 90 in here, and let's take a look. So I'm thinking, another thing that I'm thinking, $455. So yeah, that's a pretty big savings there. Another thing that I'm thinking, maybe you have filed the I-90 online, because if you are sending the 912 separately, maybe the I-90 was filed online, and in that case, if you are trying to get the fee waiver on the application, unfortunately right now there is no way to file it online. You actually have to file it by mail, because the both of the applications have to be together. So that might be another issue, but then again, even if it was started online, you can't really submit it. You can't actually file it online without paying the fee. So that's kind of like goes both ways. I'm thinking maybe it was filed, maybe it wasn't, but I'm thinking it wasn't. But let me know if you want. You can let me know follow-up information if it was actually filed or not. I'm thinking it hasn't been, but if you want, if you have any follow-up questions, or you need some kind of help with this later, let me know in the comments below. Just make sure it's a separate comment, and I will address it in the next volume of me answering the questions. Okay, let's move on to the next question from Kimberly Martinez. Kimberly says, I need to ask a question. How do I do it? Okay, there you go. So Kimberly Martinez commented with a question. There you go. Let's do it. Hello, my name is Kimberly Martinez, and my husband and I were married in January of 2002. I just filed for his papers. In 2018, they filed I-601A to ask for his forgiveness for entering the country illegally. I see. And INS received his payment, and I received his payment and fingerprints last June, but since then nothing else has happened except over time. I called a lawyer. She says, well, they moved the date up again. This is the first time. I was married once before, but I did the paperwork myself. And my ex had his green card in a year. We didn't have to ask for forgiveness. I just did I-130 and went from there. What can you tell me about the time period, and if we should have filed another way? Okay, Kimberly, thank you for your question. So it is a little bit weird because you have filed his papers in 2018. Yes, I understand there was a little bit of delay. They asked for, that 601A and, the forgiveness and stuff like this. I understand that. So there was a little bit of delay. But still, whenever it comes to spousal cases, whenever it comes to, spouse petitioning for, whether you are a U.S. citizen or whether you're a permanent resident, the only difference would be in permanent residents, there is a little bit of a backlog whenever it comes to F2A category. And for F2A, we're going to actually look at the graph A. There is about, September to 2020, so roughly about 3 years, a little bit more than 3 years. You have filed in 2018, so that is way more than what the visa bulletin is showing you. So that means even if you were a permanent resident petitioning for your spouse, and honestly, it doesn't sound like you're a permanent resident, it sounds like you're a U.S. citizen, but even if you were a permanent resident filing for a spouse, you're way over 3 years. And I understand there was a little bit of delay filing that 601A. Still, it is a little bit too much of time. So a few things I would recommend doing. It's really hard to do it through an attorney, so I would recommend, honestly, it might not be a good recommendation, because my recommendation can cause you to have problem with your attorney. Because my recommendation would be reach out directly to USCIS. Don't do it through an attorney. Reach out directly through USCIS and ask them if they have received the 601A, what is the status of 601A, whether they have issued their forgiveness that they were asking from from your husband because of his crossing the border, and if they're okay with it. Because if they are okay with it, and you are, whether you're a permanent resident or you're a citizen, then you should have already had, the approved by USCIS. The case has been approved by USCIS, transferred to the NVC, and really done with the documentary qualification. From your comment, it sounds like you didn't even get to that stage yet, that you have not even been approved by USCIS yet. And I don't want to talk anything bad about your attorney, but this is way too long of a time to wait, because it's a spousal case. It's not one of these cases where, one of these categories where, and even F2As, it's not even applicable, okay, because it's a spousal. So that's the only exception. F1, F2B, F3, F4, these are the, the situations, the categories where, people are waiting for a long time for the immigrant visa to become available, and it constantly moves ahead and ahead. And that I understand if your attorney told you, oh yeah, they moved it, now it's further. I understand that. But honestly, it sounds like you might have a little bit of a problem with your attorney. I don't want to cause a problem with your attorney, but that's what it sounds like from your comment. So, in the conclusion of my answer, it is really up to you what you want to do, which avenue you want to take. I don't want to ruin your relationship with your attorney. Maybe I'm not understanding something from what you've commented on, but like I said, it sounds like you are a U.S. citizen. You're petitioning for your husband. That is immediate relative category. You're not dealing with a backlog at all. Typically, those cases take somewhere a year and a half, 2 years. Now, I understand that you had a delay in your case. You had some extra stuff that you had to deal with, and that's I-601A. I understand that. But again, I-601A, it doesn't take that long to process again, because you have already been waiting since 2018. And that is, 5 years. It might be already 5 years. It might be more than 5 years. It might be a little less than 5 years. But you're around 5 years mark anyway. Which is way too long for, spousal cases. So it's up to you, Kimberly, how you want to deal with this. I would maybe try to reach out to an attorney once again and ask her and tell her that, something is not right. It takes a little bit too long. Be polite, be professional, always with everyone, be understanding. But at the same time, don't let this case just in the air, because if you let it go in the air, it will stay in the air. You definitely don't want to do that. You definitely want to be on top of this case, because it's definitely already taking way too long. And if your attorney is not being helpful, then I think it's it's up to you. Like you did it the first time, you did it yourself, and it's a little bit more headache. It's a little bit more researching, and it's takes time too, of your own time that you put into doing all of this. But at the same time, you know exactly what's in there. You know exactly if it was filed or not. You're, for the most part, in control of the case as much as you can be. And if you have any follow-up questions, come back to this channel and ask me in the comments. I will be happy to answer any other questions you have. All right, let's move on to the next one from Kirsten. Kirsten Hall. What is the evidence that I need to provide in an H-2B for a worker that I'm trying to bring over from Argentina? Kirsten, thank you very much. It's not Kristen, it's Kirsten, right? Sorry if I'm mispronouncing the name. I myself am an immigrant, so even the American names are sometimes hard for me. So, to petition for non-immigrant worker, you're filing the petition I-129, as you're probably already familiar with. So, I'm going to show you. It's very straightforward. We're going to go to uscis.gov forms. We're going to go to all forms, and I'm sure you already know how to find it. 129. Petition for non-immigrant worker. So that is the petition that you will be filing in order to petition for someone specifically in the H-2B category. So you can find all of the instructions. You can find the checklist, specifically checklist for H-2B. Here we go. We can open it here. And you can also scroll down here. Checklist for required initial evidence. You can use this checklist as well. And we'll scroll down. And don't worry, I'm going to put everything in my response, a link. H-2B, temporary non-agricultural worker. There we go. So here are a few documents that you have to be prepared in order to provide. And again, whenever it comes to the documents, as long as the document, establishes the eligibility, the whatever they are requesting. That it can be, for example, anything. Let me read some of this, and we will discuss it. So an approved temporary labor certification from the U.S. Department of Labor. That's one of the things that has to happen, and that is, you can't provide anything else. It has to be, approved temporary labor certification. That's it. Evidence showing each named beneficiary meets the minimum job requirements stated on the temporary labor certification. Okay. Evidence showing each named beneficiary meets the minimum job requirements. Okay. So minimum job requirements. In this situation, it can be, for example, some kind of professional certificates from the from your prospective worker, right, non-immigrant worker. For example, some kind of educational background, some kind of courses they've been taking, possibly some kind of experience that they have in whatever work that you're planning them to do here. So you see, there can be a variety of different kind of evidence that you can provide. So it's not anything specific, but as long as it provides the evidence that establishes what they're requesting, then you're good. Evidence showing it is in the U.S. interest for the non-citizen to be the beneficiary if requesting a national form from a country not on the H-2B eligible countries list. Again, there's a list, the countries that are preferred for the H-2B non-immigrant workers to come here and work. But if they're not from that country, you can file an exemption, have an exemption. In that case, you will just have to provide why it is in the interest of U.S. And again, it can be a variety of different evidence that you can provide, supporting documentation, showing that, for example, they will be working in an undeveloped area, which will create some kind of benefit for U.S. economy, maybe for employment rates. Maybe you will be able, if you bring this non-immigrant worker and they start, you will be able to later employ local, U.S. nationals as your employees. Evidence showing it is in the U.S. interest, so that's it. Evidence the beneficiary maintains status if they are seeking a change of status or extension of stay. Okay, that's very specific. And then, of course, you have some more checklist requirements here, and this is going into more detail. So let me copy both of these. Let me put this right here, and I'm gonna do it. Let's see if I can do it. Yep, link 1. Hopefully it will open up, but now you know where to find this. Link 2. Alrighty, and if you have any follow-up questions, don't hesitate to come back and ask them. Just make sure you ask them in the separate comment. Alrighty, let's move on to the next question. Okay, looks like 2 comments from Andrea Miller. Thank you for his update. I guess this update. You're very welcome, Andrea. Thanks for watching. Andrea Miller says, Graph B for F4. Where is it, please? On brother and sister with priority date 2010. True people are stressed and need to help themselves financially. Okay, Andrea. So F4, Graph B with priority date 2010. So priority date 2010. So if we're looking at the Graph B, and the Graph B is showing us when the NVC portal is going to be fully open so that you can start your documentary qualification process. If we're looking at all chargeability area, F4 right here, brothers and sisters, right now it is on March 2008. So if your priority is in 2010, it means you are roughly 2 years away from the NVC portal fully opening up to start that documentary qualification process. So 2 years is quite a long time, but looks like you've already done most of the waiting, so you're getting closer and closer to the finish line. Just a little bit more, Andrea. Just a little bit more. Alrighty, let me put this, and we're gonna move on to the next question from Pawan Yadav. Sorry if I'm mispronouncing the name. So Pawan says, what are your predictions for EB1 India forward movement? Pawan, that's a great question. It's really hard to answer, because there is something happening for, specifically for India whenever it comes to the employment-based categories. And I'm thinking, obviously, and probably not me thinking, more so obvious reason for that is that the numbers of Indian immigrants coming based on employment, right, immigrating to the US is very, very high. And as of recently, we've seen one of the categories on the visa bulletin as of July 2023, we have seen specifically for India chargeability area, move back as far as 3 years, which I have not seen a huge movement like this on the visa bulletin ever before. So there is conversation going on, and there is actually some explanation that these guys are trying to do here on this website at the very bottom right here, the retrogression in the employment-based third preference, and that's specifically for third preference for India. As readers were informed, was possible in item E of the June 2023 visa bulletin. It has become necessary to retrogress the EB3 final action date for India effective in July. India's EB3 number use has been consistently robust throughout the fiscal year, and it is estimated that applicants chargeable to India will use all EB3 numbers made available to them during this fiscal year, taking into account the INA 202 by the end of June. Thus, applicants from India are subject to a final action date of 1st January 2009. The situation will be continually monitored, and any necessary adjustments will be made accordingly. And there is actually a conversation that is potential that they might even do this as unauthorized, where they don't issue any immigrant visas because the numbers are growing. My personal predictions for the EB1, based on the third category, I'm thinking it will slowly spread, and looks like the EB3 was the kind of the epicenter of all of this for India, but I think it will spread on all of the other categories as well, little by little, because it really is typical whenever it comes to one specific category, especially whenever it comes to employment-based. You have to understand, with family preferences, you really don't have an option. You only have an option between the F1 and the F2B, where if the petitioner becomes from permanent resident to the, becomes naturalized U.S. citizen, you have an option to switch from F2B to F1. And sometimes it's beneficial to be in F2B, and sometimes it's beneficial to switch it to F1. It's there is a gamble there. But with employment-based visas, you can do it with pretty much any of the categories, because if you look at the third preference categories and you're like, wow, I'm from India, for January 2009, I'll never be able to take care. So let me see what I can do in order to potentially, maybe instead of the third preference category, do a second preference category, and maybe instead of the second preference category, be in the first preference category. Maybe I can get some higher education, maybe I can find a different employer, maybe I can increase my chances of qualifying in the first preference category. So there's always an option like that, and I think people will start taking advantage of this now, especially if they turn it into unauthorized, because there's so many such a huge backlog that is occurring on these. Because another thing you have to keep in mind, and I'm sorry if I'm making this answer way too long for you, but it is a good question, and it is an interesting discussion, really. Because with family preference, let's say if I petitioned for my brother, which I did, and we're going to be waiting for another 13 years, that's just what we have to deal with. And in 13 years, my brother is not going to become somebody else. He will still be my brother, all right? So if in 13 years, hopefully nothing bad happens and we still are, waiting, and he comes here, great, fantastic, even if it takes 13 years. With employment-based, however, that's not really the situation. If somebody had filed back in January 2009, if for some reason something happens with the company, or maybe they're not here in the United States, or there can be a lot of different circumstances. There isn't a lot of employers out there that are willing to sponsor someone and wait. Well, as of right now, what is it? In third preference category for India, and fourth preference category from India, and even the second preference category, because it's January 2011, which is still ridiculously long time. What? My math is horrible. So 14 years. 14 years, an employer waiting for an employee. That must be a very, very special employee if an employer is waiting for 14 years. So you see, it creates a lot of problems, and that's one of the reasons why a lot of people are speculating that they might make it unauthorized, where they don't accept any more additional applications specifically for India chargeability area. Again, that's a speculation, but we will see. We will see. I think in the next few months, And it's weird because I literally just started getting into the employment-based categories visa bulletin, because mostly I was doing the family preference categories. So I will start from now on. I will keep making the visa bulletin videos on employment-based categories as well, and we will see. We will see in the next few months. That's the best, always thing to do, because 1 month, 2 months, 3 months, the more you kind of have in order to combine them together and see where it's all going. If it's a positive movement, if it's a negative movement, then we will be able to kind of draw more or less decent conclusion, because right now it's really hard, because it's really the first months that we see this retrogression. So Pawan, thank you very much for your question. I really appreciate it, and for everyone else, I really appreciate your questions today. Hopefully my answers were helpful. If you have any follow-up comments, questions, let me know. I will be happy to address them in the next volume. Thank you very much for watching. God bless, and I'll see you all in the next video.